back.
And we're back.
Hello, and welcome to this week's edition of Law for You.
This week, we have quite the cases to discuss.
Yes, quite the cases. Let us begin with the infamous Escola versus Coca-Cola case.
Infamous.
Picture this, folks. The year is 1944, and you're putting away some of those iconic glass bottles of Coke. One explodes in your hand and leaves a 5-inch long gash.
Well, this is exactly what happened to our dear friend Gladys Escola. And what does she decide to do?
Sue the company, of course.
Of course, the only reasonable course of action to take. She claimed that Coca-Cola should be held responsible for selling bottles they knew were unsafe and capable of causing injury. Well, were they?
Aren't they all?
You've got a strong point there, Minnie. Before we dig any deeper, let's cover some terminology that our audience might not be familiar with.
Phenomenal idea, Heidi. First, let's talk about product liability.
Okay, folks, so product liability is the legal liability a manufacturer or trader incurs for producing or selling a faulty product. And now, I'll throw it back to you, Minnie.
All right, strict liability is a liability which does not depend on actual intent to harm or negligence. It is imposed without the finding of a fault. The defendant just needs to prove that the harm occurred for which the defendant was responsible.
So, some of you may be asking, how are these even related? I'll let Minnie answer that one.
Well, both of them relate to the liability of a manufacturer for the harm caused by their product, but one of them is more broad of a term and implies that while the defendant was responsible, it wasn't on purpose, while the other implies that the manufacturer sold a product knowing that it was faulty.
Ugh, some people are utterly despicable.
Utterly.
So, let's talk about how things ended for good old Gladys.
Justice Phil S. Gibson confirmed that even though Coca-Cola was not directly responsible for the bottle and the injury caused to the defendant at the time of the crime, they had control of the bottle during the time it was filled and showed negligence by not making sure the bottle was safe.
But Justice Roger Traynor argued that instead of the case accusing the company of negligence, a rule of strict liability is imposed instead. He said that the California state law already placed strict liability on manufacturers whose products cause disease or injury to customers. Because if charges of negligence were fairly similar to charges of strict liability in the first place, he argued that it was a more practical standard.
Interesting.
Interesting indeed. Luckily, this case sets a precedent, so manufacturers will be held liable for selling products which are defective and cause disease or harm to customers. They will be held to a standard of product liability which charges them with the negligence for selling a product which was faulty at the time of production.
All right, now that we've got that all wrapped up, let's jump ship to 2011.
All right, folks, the year is 2011 and you're a minor looking to play some video games. Harmless fun, correct?
No, Heidi, incorrect. Very incorrect, according to a newly enacted California law.
So, associations of companies that create, publish, distribute, sell, and or rent video games brought a declaratory judgment action against the state of California in a California federal district court. The plaintiffs brought the claim under the First and 14th Amendments, seeking to invalidate a newly enacted law that imposed restrictions and labeling requirements on the sale or rental of violent video games to minors. The district court found in favor of the plaintiffs and prevented the enforcement of the law.
Imagine being a minor and not being able to play violent video games. What would you even resort to?
Death, I suppose.
The Court of Appeals thankfully clarified that 1. Violent video games did not constitute obscenity under the First Amendment. 2. The state did not have a compelling interest in preventing psychological or neurological harm to minors allegedly caused by video games. And 3. Even if the state had a compelling interest, the law was not narrowly tailored enough to meet that objective.
Yes, thankfully. It was a 7-2 decision in the Supreme Court, and in the words of Scalia, like the protected books, plays, and movies that preceded them, video games communicate ideas and even social messages through many familiar literary devices such as characters, dialogue, plot, and music. And through features distinctive to the medium, such as the player's interaction with the virtual world, that suffices to confer First Amendment protection.
With that resolution, we're wrapping up the show.
To all of our loyal viewers out there, thank you and good day.